225 ILCS 225/4 from CH 111.5 par 116.304 Sector 4. A. After January 1st, 1974, no person or private sewage disposal system contractor may construct, install, modify, repair, maintain, or service a private sewage disposal system or transport and dispose of waste removed therefrom, in such a manner that does not comply with the requirements of this Act and the Private Sewage Disposal Code promulgated hereunder by the Department. A person who owns and occupies a single-family dwelling and who constructs, installs, maintains, services or cleans the private sewage disposal system which serves his single-family residence shall not be required to be licensed under this Act. However, such person shall comply with all other provisions of this Act and the Private Sewage Disposal Code promulgated hereunder by the Department. Any person who constructs, installs, repairs, modifies, or maintains a private sewage disposal system other than a system which serves his own single-family residence shall be licensed by the Department as a private sewage system installation contractor, and any person who cleans or pumps waste from a private sewage disposal system, other than a system which serves his own single-family residence, or hauls or disposes of wastes removed therefrom shall be licensed by the Department as a private sewage disposal system pumping contractor in accordance with this Act. B. No new private sewage disposal system shall be installed by any person until drawings, specifications, and other information requested by the Department are submitted to and reviewed by the Department and found to comply with the Private Sewage Disposal Code, and until approval for the installation of such system is issued by the Department. C. The licensing requirements of this Act shall not apply to any person who cleans or pumps, hauls, or disposes of waste from chemical toilets located in an underground coal mine. This waste shall be I. Transported to and disposed of at a sewage treatment facility permitted by the Illinois Environmental Protection Agency and located on the mine property, or 2. Stored 2. On-site in a sanitary manner pending removal and subsequent disposal by a licensed private sewage disposal pumping contractor. D. There is hereby created in the State Treasury a special fund to be known as the Private Sewage Disposal Program Fund. All fees collected by the Department for exams, licenses, permits, and fines in accordance with this Act shall be deposited into the fund and shall be appropriated by the General Assembly to the Department. Gifts, grants, and other monies from any source available for this purpose may be deposited into the fund. Subject to appropriation, money from this fund shall be used by the Department to administer this Act. Interest attributable to monies in this fund shall be returned to the fund. Monies in the fund shall be appropriated and used only for the purposes stated in this Act. Source PA 96-767, F. August 28, 09. 225 ILCS 225/5 from CH 111.5 par 116.305 Sector 5. A. The Director shall issue a private sewage system installation contractor license or a private sewage disposal system pumping contractor license to persons applying for such license who successfully pass a written examination prepared by the Department and who pay the required annual license fee in an amount determined by the Department. Each person who holds a currently valid plumbing license issued under the Illinois Plumbing License Law, as now or hereafter amended, shall not be required to pay the annual license fee required by this section, but such licensed person shall comply with all other provisions of this Act, including the requirement for examination for licensure. B. A license issued under this Act shall expire on December 31st of the year issued, except that an original license issued after October 1st and before December 31st shall expire on December 31st of the following year. The Department shall reinstate a license which expires while a licensee is in the active military service of the United States upon application to the Department by the former licensee within 2 years after termination of such military service, payment of the annual license fee and submission of evidence of such military service. Such license shall be reinstated without examination and without payment of the reinstatement fee. C. A private sewage disposal system pumping contractor or a private sewage system installation contractor whose license has expired for a period of less than 3 years may apply to the Department for reinstatement of his license. The Department shall issue such renewed license provided the applicant pays to the Department all lapsed license fees, plus a reinstatement fee determined by the Department. A license which has expired for more than 3 years may be restored only by reapplying to take the examination and by successfully passing the written examination. Source PA 85-1261. 225 ILCS 225/5A from CH 111.5 par .116.305A Sector 5A. All applicants shall be tested and required to attain a passing grade prescribed by the Department on an examination which evaluates the applicant's general knowledge of the design, installation. 3. Operation, maintenance, and servicing of on-site wastewater disposal systems. Applications for examination shall be in the form prescribed by the department and shall be accompanied by the required fee determined by the department. The department shall conduct written examinations at least 2 times a year and may require a practical demonstration by each applicant. The written examination shall be prepared by the department. Persons holding a valid license on the effective date of this Amendatory Act of 1985 shall be required to pass the written examination by December 31st, 1989. A license will not be renewed after December 31st, 1989, unless the person holding the license has successfully passed the written examination. Source PA 84 to 670. 225 ILCS 225/5B, Sector 5B. Licensure required for the maintenance of portable toilets and potable hand washing units. Cleanliness standards. A. The department shall by rule establish and issue a separate license, independent of any other license issued under this Act, for the pumping, hauling, and disposal of wastes removed from the sewage disposal systems of portable toilets and potable hand washing units and the cleaning, sanitizing, and maintenance of portable toilets and potable hand washing units to qualified businesses responsible for the pumping, hauling, and disposal of wastes removed from the sewage disposal systems of portable toilets and potable hand washing units and the cleaning, sanitizing, and maintenance of portable toilets and potable hand washing units. These rules shall concern, but not be limited to, all of the following areas. 1. License duration and expiration, renewal, reinstatement, and inactive status. 2. All fees relating to initial licensure and renewal. 3. Licensure application form and process. 4. Violations and penalties. 5. Exemptions and waivers. 6. Ventilation, safety, and security requirements of portable toilet units and the sewage disposal systems of portable toilet units. 5. The department shall by rule establish and issue a certificate of registration as a portable sanitation technician for any employee of a business licensed under this section who engages in the servicing of portable toilets and potable hand washing units and the cleaning, sanitizing, and maintenance of portable toilets and potable hand washing units. Beginning 6 months after the date of the adoption of department rules implementing the provisions of this Amendatory Act of the 95th General Assembly, no person may engage in the servicing of portable toilets in a manner that does not comply with the requirements of this Act and the rules established by the department under this Act concerning the issuance of a certificate of registration as a portable sanitation technician. Prior to a registrant's initial renewal of his or her certificate of registration, the registrant must complete a certification program approved by the department. B. Beginning 6 months after the date of the adoption of department rules implementing the provisions of this Amendatory Act of the 95th General Assembly, no person or business may engage in the pumping, hauling, and disposal of wastes removed from the sewage disposal systems of portable toilets and potable hand washing units and the cleaning, sanitizing, 4. and maintenance of portable toilets and potable hand washing units without being licensed or certified under this section. C. The department shall require the successful completion of an examination prescribed by the department prior to licensure. The department may accept the Portable Sanitation Association International's Health and Safety Certification Program as an acceptable educational and testing program. D. The department shall consider and make any necessary amendments to the Private Sewage Disposal Code in relation to a license issued for the pumping, hauling, and disposal of wastes removed from the sewage disposal systems of portable toilets and potable hand washing units and the cleaning, sanitizing, and maintenance of portable toilets and potable hand washing units. E. The department shall establish and enforce standards of cleanliness for companies that sell, lease, rent, or otherwise maintain portable toilet units and potable hand washing units for commercial purposes, which shall include, but not be limited to, the following requirements. 1. Each unit shall be thoroughly cleaned at each pumping, including all parts of the unit, which are the urinal, tank, walls, floors, door, and roof. 2. Soap or antibacterial hand cleaner and paper products shall be refilled in each unit at each pumping, if required. 3. After a unit is cleaned, it shall be inspected to ensure compliance with department rules concerning the ventilation, safety, and security of the unit. 4. A company shall designate at least one representative who shall be responsible for ensuring that each unit maintained by the company meets the standards of cleanliness set forth in this subsection D, and any additional standards established by the department. 5. Those persons engaging in cleaning units shall wear protective equipment and be trained in proper procedures for sanitation and self-protection. Source PA 94 to 138, F July 7th, 05, 95 to 701, F November 29th, 07. 225 ILCS 225 to 6, from CH 111.5, par. 116.306, Sector 6. Property owners of all buildings and places where people live, work, or assemble shall provide for the sanitary disposal of all human wastes and domestic sewage. Human wastes and domestic sewage from such buildings and places shall be disposed of by discharging into a sewerage system operated and maintained under permit of the Illinois Environmental Protection Agency, if reasonably available, or if such sewerage system is not available, then such disposal shall be in compliance with this Act and the Private Sewage Disposal Code promulgated under this Act. Source PA 78 to 812. 225 ILCS 225-7, from CH 111 1/2, par. 116.307, Sector 7. A. The Department shall promulgate and publish and may from time to time amend a private sewage disposal code which shall include minimum standards for the design, construction, materials, operation and maintenance of private sewage disposal systems, for the transportation and disposal of wastes removed therefrom and for private sewage disposal system servicing equipment. In the preparation of the private sewage disposal code, the Department may consult with and request technical assistance from other state agencies, and shall consult with other v. Technically qualified persons and with owners and operators of such services. Such technically qualified persons shall representatives of the real estate, development, and building industries. B. The Department is expressly prohibited from amending the private sewage disposal code by rule if there are increases in the land density requirements. Amendments that increase the land density requirements must be approved by the Illinois General Assembly. C. Beginning January 1st, 2013 or 6 months after the date of issuance of a general NPDES permit for surface discharging private sewage disposal systems by the Illinois Environmental Protection Agency or by the United States Environmental Protection Agency, whichever is later, a surface discharging private sewage disposal system with a discharge that enters the waters of the United States, as that term is used in the Federal Water Pollution Control Act, shall not be constructed or installed by any person unless he or she has a coverage letter under an NPDES permit issued by the Illinois Environmental Protection Agency or by the United States Environmental Protection Agency, or he or she constructs or installs the surface discharging private sewage disposal system in a jurisdiction in which the local public health department has a general NPDES permit issued by the Illinois Environmental Protection Agency or by the United States Environmental Protection Agency, and the surface discharging private sewage disposal system is covered under the general NPDES permit. The private sewage disposal code must be amended before January 1st, 2013 to comply with this subsection. D. Except as provided in subsection C of this section, before the adoption or amendment of the private sewage disposal code, the Department shall hold a public hearing with respect thereto. At least 20 days' notice for such public hearing shall be given by the Department in such manner as the Department considers adequate to bring such hearing to the attention of persons interested in such code. Notice of such public hearing shall be given by the Department to those who file a request for a notice of any such hearings. Source PA 96 to 801, F January 1st, 10, 97 to 1081, F August 24th, 12. 225 ILCS 225 to 8, from CH 111 1/2, par. 116.308, Sector 8. A. In addition to promulgating and publishing the private sewage disposal code, the Department has the following powers and duties. 1. Make such inspections as are necessary to determine satisfactory compliance with this Act and the Private Sewage Disposal Code. 2. Cause investigations to be made when a violation of any provisions of this Act or the Private Sewage Disposal Code is reported to the Department. 3. Subject to constitutional limitations, by its representatives after identification, enter at reasonable times upon private or public property for the purpose of inspecting and investigating conditions relating to the administration and enforcement of this Act and the Private Sewage Disposal Code. 4. Institute or cause to be instituted legal proceedings in the Circuit Court by the State's Attorney of the county where such noncompliance occurred or by the Attorney General of the State of Illinois in cases of noncompliance with the provisions of this Act and the Private Sewage Disposal Code. 5. Evaluate all experimental use permits in existence on August 14, 2008, the effective date of Public Act 95 to 824, in accordance with the established conditions of approval. 6. For each permit, after the date of approval, the Department shall not issue any new experimental use permits, but may instead issue site-specific approval for performance-based systems in accordance with this section. 6. Adopt minimum performance standards for private sewage disposal system contractors. 7. Issue an annual license to every applicant who complies with the requirements of this Act and the Private Sewage Disposal Code and who pays the required annual license fee. 8. Collect an annual license fee in an amount determined by the Department from each contractor and any examination and reinstatement fees. 9. Prescribe rules of procedure for hearings following denial, suspension, or revocation of licenses as provided in this Act. 10. Authorize the use of alternative private sewage disposal systems that are designed by a professional engineer licensed under the Professional Engineering Practice Act of 1989 or an environmental health practitioner licensed under the Environmental Health Practitioner Licensing Act and accepted by the Department on a case-by-case basis where the proposed design reasonably addresses issues particular to the proposed system, including without limitation flow volume projections, wastewater composition and pre-treatment, treatment and flow in the subsurface environment, and system ownership and maintenance responsibility. B. The Department may review alternative technology and operational data from the appropriate state agency of another state, from another government entity, or from an independent testing organization to determine whether approval of components or private sewage disposal systems within the state is appropriate. The request for approval shall be made on forms approved by the Department. C. The Director shall authorize the use of appropriate new innovative wastewater treatment systems to best protect public health, the environment, and the natural resources of the state. Source PA 95 to 656, F10-11-07, 95 to 824, F August 14, 08, 96 to 328, F August 11, 09. 225 ILCS 225/9, from CH 111.5, par. 116.309, Sector 9. In the administration and enforcement of this Act and the Private Sewage Disposal Code, the Department may designate and use full-time municipal, district, county, or multiple county health departments as its agents. Source PA 78 to 812. 225 ILCS 225 out of 10, from CH 111.5, par. 116.310, Sector 10. A. This Act does not prohibit the enforcement of ordinances of units of local government establishing a system for the regulation and inspection of private sewage disposal contractors and a minimum code of standards for design, construction, materials, operation, and maintenance of private sewage disposal systems, for the transportation and disposal of wastes therefrom, and for private sewage disposal systems servicing equipment, provided such ordinance establishes a system at least equal to state regulation and inspection. Such units of local government who wish to be approved shall submit a copy of such ordinance including all amendments to the 7. Department requesting approval for such system of regulation and inspection. If such plan is approved by the Department, the ordinance shall prevail in lieu of the state licensure, fee, and inspection program, and the Department shall issue written approval. Not less than once each year the Department shall evaluate the program to determine whether such program is being operated in accordance with the approved provisions of existing ordinances. If the Department finds after investigation that such program is not in accordance with the approved program or is not being enforced, the Director shall give written notice of the findings to the Chief Administrative Officer of such unit of local government. If the Department thereafter finds, not less than 30 days after the giving of such notice, that the program is not being conducted in a manner consistent with existing ordinances, the Director shall give written notice of such findings to the Chief Administrative Officer of the unit of local government and administrative hearing as provided in this Act. All persons then operating under such unit of local government shall be immediately subject to the state licensure, fee, and inspection program. B. This Act does not prohibit the enforcement of ordinances of units of local government that require homeowners who maintain a private sewage disposal system within the unit of local government to provide verification, no more frequently than once every 3 years, to the unit of local government of a valid contract with a licensed private sewage disposal system installation contractor. However, no additional fee may be charged for such verification. Source PA 95 to 919, F August 26, 08. 225 ILCS 225/10.5, Sector 10.5 Advisory Commission. A. There is hereby created the Advisory Commission on Private Sewage Disposal, which shall consist of 17 members to be appointed from time to time by the Director. Of the initial appointments, 5 members shall be appointed to serve a 1-year term, 5 members to serve a 2-year term, and 7 members to serve a 3-year term. The Advisory Commission shall be comprised of at least one representative of each of the following: the Illinois Public Health Association, the Home Builders Association of Illinois, the Illinois Association of Realtors, the Illinois Environmental Protection Agency, the Illinois Environmental Health Association, the On-Site Wastewater Professionals of Illinois Incorporated, the Illinois Association of Local Environmental Health Administrators, the Illinois Precast Concrete Association, the Illinois Land Improvement Contractors Association, the Illinois Soil Classifier Association, and the Illinois On-Site Wastewater Association. The Director shall appoint 1 member to serve as chairperson. B. The Advisory Commission shall advise and aid the Director in 1. Reviewing and suggesting changes to the state code developed under Section 7, including but not limited to proposing performance-based standards for the design, construction, operation, and maintenance of private sewage disposal systems. 2. Propose methods for funding private sewage disposal services and for reimbursement of units of local government for expenses incurred in administering this act as agents of the state. 3. Examining the need for more stringent licensing requirements under this act, including but not limited to an apprenticeship program as a condition of original licensure and the issuance of advanced skill licenses. 4. Developing continuing education requirements for persons licensed under this act. 8. 5. Considering the need for continuing testing programs for private sewage disposal systems. 6. Developing a research and development program to examine private sewage disposal issues that affect public health and examining funding options for the program. 7. Developing a training center to educate all persons interested in learning more about on-site sewage disposal and to work with universities to provide that education. 8. Developing an experimental use permit program to set criteria for testing and reviewing new systems or innovative systems or devices and to consider oversight of this program by the Advisory Commission. 9. Examining the need for a uniform state license to install, construct, maintain, or operate systems or to pump, haul, or dispose of septage without the need for a license from a unit of local government. And 10. Performing other duties from time to time on the request of the Director. C. The Advisory Commission shall submit an annual report to the Director regarding its findings and recommendations under subsection B. D. Members of the Advisory Commission may be reimbursed for actual and necessary expenses incurred in the performance of their duties under this Act. E. Members of the Advisory Commission shall be immune from suit in any action based on an act performed in good faith as a member of the Advisory Commission. F. The Advisory Commission shall meet at least semi-annually. G. A state officer, department, board, agency, division, or commission or unit of local government may provide a service to the Advisory Commission that is 1. Requested by the Advisory Commission and 2. Within the scope of the persons or entities' governmental functions as established by law. Source PA 90-151, F. July 23, 97. 225 ILCS 225/11, from CH 111.1/2, PowerPoint 116.311, Sector 11. Notice of violation. Whenever the Department determines that there are reasonable grounds to believe that there has been violation of any provision of this Act or the rules and regulations issued under this Act, the Department shall give notice of such alleged violation as herein provided. Such notice shall, a. be in writing, b. include a statement of the reasons for the issuance of the notice, c. allow reasonable time as established by rule for the performance of any act it requires, d. be served upon the owner, operator, or licensee as the case may require, provided that such notice or order shall be deemed to have been properly served upon such owner, operator, or licensee when a copy thereof has been sent by registered or certified mail to his last known address as furnished to the Department, or when he has been served with such notice by any other method authorized by the laws of this state, and e. contain an outline of remedial action, which is required to effect compliance with this Act and the rules and regulations issued under this Act. Source PA 92-353, F. August 15, 01. 9. 225 ILCS 225/12, from CH 111.5, PowerPoint 116.312, Sector 12. The Department must in any proceeding to suspend, revoke, or refuse to issue a license, first serve or cause to be served upon the applicant, or licensee a written notice specifying the way or ways in which such applicant or licensee has failed to comply with this Act, or any rules, regulations, or standards promulgated by the Department pertaining thereto. In the case of a revocation or suspension, this notice shall require the licensee to remove or abate such violations, in sanitary or objectionable condition, specified in such notice, within 5 days, or within a longer period of time as may be allowed by the Department. If the licensee fails to comply with other terms and conditions of the notice, within the time specified or such extended period of time, the Department may revoke or suspend such license. If an applicant fails to comply with this Act, rules or regulations or standards promulgated under this Act, the Department may refuse to issue a license. Source PA 78-812. 225 ILCS 225/13, from CH 111.5, PowerPoint 116.313, Sector 13. The Department shall give written notice by certified or registered mail to any person refused a license or whose license is suspended or revoked, or an approved unit of local government whose approval is denied, suspended, or revoked, or any person in violation of the Act, rules, and regulations. Such person has a right to a hearing before the department. However, a written notice of a request for such a hearing must be served on the department within 10 days of notice of such refusal of a license or suspension or revocation thereof or notice of violation. The hearing shall be conducted by the director, or a hearing officer designated in writing by the director, to conduct the hearing. A stenographic record shall be made of the hearing and the cost borne by the department. However, a transcription of the hearing will be made only if a person requests it and shall be transcribed at the cost of such person. The hearing shall be conducted at such place as designated by the department. The director shall give written notice of the time and place of hearing, by registered or certified mail, to the owner, operator, licensee, or applicant, as the case may be, at least 20 days before such hearing. The director or hearing officer shall permit the licensee, applicant, person, or unit of local government to appear in person or to be represented by counsel at the hearing, at which time such party shall be afforded an opportunity to present all relevant matter in reference thereto. Source PA 84-670. 225 ILCS 225/14, from CH 111.5, PAR.116.314, Sector 14. The director or hearing officer may compel by subpoena or subpoena duces tecum the attendance and testimony of witnesses and the production of books and papers and administer oaths to witnesses. All subpoenas issued by the director or hearing officer may be served as provided for in a civil action. The fees of witnesses for attendance and travel shall be the same as the fees for witnesses before the circuit court and shall be paid by the party to such proceeding at whose request the subpoena is issued. If such subpoena is issued at the request of the department, the witness fee shall be paid as an administrative expense. In cases of refusal of a witness to attend or testify, or to produce books or papers, concerning any matter upon which he might be lawfully examined, the circuit court of the county where the hearing is held, upon X application of any party to the proceeding, may compel obedience by proceeding as for contempt. Source PA 83-334. 225 ILCS 225/15, from CH 111.5, PAR.116.315, Sector 15. In the event of the inability of any party or the department to procure the attendance of witnesses to give testimony or produce books and papers, such party or the department may take the deposition of witnesses in accordance with the laws of this state. All testimony taken at a hearing shall be reduced to writing, and all such testimony and other evidence introduced at the hearing shall be a part of the record of the hearing. Source PA 78-812. 225 ILCS 225/16, from CH 111.5, PAR.116.316, Sector 16. The director shall make findings of fact in such hearing, and the director shall render his decision within 30 days after the termination of the hearing, unless additional time is required by him for a proper disposition of the matter. When the hearing has been conducted by a hearing officer, the director shall review the findings of fact and recommendations of the hearing officer, and the transcribed record if a party has requested and paid for such record before rendering a decision. It shall be the duty of the director to forward a copy of his decision, by registered or certified mail, to the owner, operator, licensee, applicant, or local health department, as the case may be, within 5 days of rendition of such decision. Technical errors in the proceeding before the director or hearing officer or their failure to observe the technical rules of evidence shall not be grounds for the reversal of any administrative decision unless it appears to the court that such error or failure materially affects the rights of any party and results in substantial injustice to him. Source PA 78-812. 225 ILCS 225/17, from CH 111.5, PAR.116.317, Sector 17. The department is not required to certify any record or file any answer or otherwise appear in any proceeding for judicial review unless the party filing the complaint deposits with the clerk of the court the sum of $1 per page representing costs of such certification. Failure on the part of the plaintiff to make such deposit shall be grounds for dismissal of the action. Source PA 78-812. 225 ILCS 225/18, from CH 111.5, PAR.116.318, Sector 18. Whenever the department finds that an emergency exists, including those within programs approved in Section 10, which requires immediate action to protect the public health, it may, without any administrative procedure and without notice, hearing, or bond bring an action for a temporary restraining order or a preliminary injunction to require that such action be taken as the court may deem necessary to meet the emergency, including the suspension or revocation of the license. Notwithstanding any other provision in this act, such order shall be effective immediately. Such action shall be brought by the state's attorney of the county in which the violation occurred or by the Attorney General in the name of the people of the state of Illinois. 11. When such conditions are abetted, in the opinion of the department may request and the court may enter an order that the temporary restraining order or a preliminary injunction be dissolved. Source PA 83 to 342. 225 ILCS 225/19 from CH 111.5, PAR.116.319, Sector 19. Civil and criminal penalties. Any person who violates this act or any rule or regulation adopted by the department under this act or who violates any determination or order of the department under this act shall be guilty of a Class A misdemeanor and shall be fined a sum not less than $100. Each day's violation constitutes a separate offense. B. In addition to any other penalty provided under this act, the department, or a unit of local government acting under Section 10, in an administrative proceeding, or the court in an action brought under subsection C of this section, may impose upon any person who violates this act or any rule or regulation adopted under this act, or who violates any determination or order of the department under this act, a civil penalty not exceeding $1,000 for each violation plus $100 for each day that the violation continues. C. The state's attorney of the county in which the violation occurred or the attorney general may bring actions for the enforcement of this act and the rules adopted and orders issued under this act, in the name of the people of the state of Illinois, and may, in addition to other remedies provided in this act, bring an action for an injunction to restrain any actual or threatened violation, or to enjoin the operation of any establishment operated in violation, or to impose or collect a civil penalty for any violation. Source PA 92 to 353, F. August 15, 01. 225 ILCS 225/20 from CH 111.5, PAR.116.320, Sector 20. Nothing in this act shall be construed to exclude the state of Illinois and departments thereof except that the